Okay, hello everyone. We've been talking about the ways contracts can be discharged, how to discharge a contract, and we've said that contracts, there are 4 basic ways. It doesn't mean that there are not other ways, but there are 4 primary ways of discharging a contract. And the first one is that a contract can be discharged by performance. A contract can be discharged by breach. A contract can be discharged by agreement and by frustration. So in this recording, we are going to be talking about discharge of contract by breach. So a breach of contract actually means the failure of a party to perform his obligation according to the terms of the contract. It actually occurs where a party fails to perform his obligations, under the contract without a lawful excuse or without legal justification. It could also mean that the party has performed his obligations, but did not perform it satisfactorily, and the contract came to an end due to that. So breach is basically divided into 2: actual breach and anticipatory breach. Actual breach and anticipatory breach. So actual breach actually happens where a party does not perform his obligations according to the terms of the contract, at the time of performance. For it to be actual breach, it means that performance has arisen, it's time to perform, and at that time of performance, that party has, failed to perform his obligation. So remember that when a contract is discharged, it means that the parties are free from their rights and their obligations. So any obligation that has arisen or that is still subsisting is terminated. So while breach of contract entitles the innocent party to claim damages, not all breach would justify or entitle the innocent party to terminate the contract, to repudiate the contract. For instance, if it is a breach of a condition or the breach of a fundamental term, that would entitle the innocent party to terminate the contract. But then if it's a breach of a warranty, which is a less important term, it would not entitle the innocent party to terminate the contract. What it can actually do is to entitle the innocent party to damages, but not to terminate or to repudiate the contract. So actual breach, does not automatically, as I said, it does not automatically discharge the parties from their obligations. Just because a breach has happened does not mean that, the contract will be automatically considered discharged. So if it is a breach of a condition, right, the innocent party has the option to consider that breach, right, to consider that breach one that can discharge the contract. So the innocent party has the option to either discharge that contract or to not discharge the contract and keep it subsisting. So the innocent party is basically, is basically not compelled. It doesn't have to, it doesn't have to accept the breach and terminate the contract. He can choose to affirm that contract and keep it alive and, and reserve his rights to sue for damages. So just because he has kept it alive and he has accepted it and affirmed, it doesn't mean that the innocent party can't sue for damages. So before we go ahead and talk about anticipatory breach, right, let's talk about fundamental breach. we've talked about conditions and warranties. Fundamental breach is, it occurs where a party breaches or breaks the contract in such a way that it goes to the very root of the contract. So it almost sounds, it almost sounds like a condition, but I would like to refer a fundamental breach as, much more severe than a condition. So a fundamental breach is the breach of a term that constitutes the main purpose of the contract. The term that when it's breached, it goes to the very root of the contract. So failure to comply with such a fundamental term is equivalent to not even performing the contract in the first place. And you would see that in Suzy Atlantic and in Photo Production and Securico Transport Limited. So fundamental breach, when a fundamental breach happens, it allows the innocent party to treat the contract as terminated, even if the breaching party did not explicitly repudiate that contract. So the difference between a fundamental breach and the breach of a fundamental term is that, the fundamental term focuses on the importance of the term that has been broken, right? But fundamental breach focuses on the impact of the breach. Was the breach the type that is so fundamental that it results to the party not, it results to the party not gaining anything from the contract. It results to it goes to the very root of the contract that it breaks up that contract if it is allowed, right? So when a fundamental breach happens, the innocent party has the right to terminate that contract, to discharge it, and and bring it to an end. In other words, when he brings to an end, he's no more required to perform his own obligations. The innocent party also has, the innocent party also has the right or the entitlement to claim damages in addition to terminating the contract. Okay, so now let's talk about anticipatory breach. You know that we talked about actual breach, right? Actual breach is where the breach happens at the time of performance. Anticipatory breach is where it refers to, the breach that happens before the time of performance. So the time of performance has not yet arisen when the party intimated the other party or indicated to the other party that at the time of performance, he would not be able to perform his own contractual obligations. So this can happen either by words or by conduct. It can happen either expressly or impliedly, right? An example is in Hochster against Delatour. So in that case, the defendant employed the services of the plaintiff to serve as a courier, like a tour guide, right, for like 3 months from June. But in May, right, the defendant wrote a letter to the plaintiff informing him that he would no longer need his services. So the plaintiff sued for breach of contract. So the question before the court was whether the plaintiff could sue for breach that had not yet occurred. Remember that, the tour was supposed to happen in June. Performance was supposed to happen in June. But the repudiatory letter, because another name for anticipatory breach is repudiation. Please, let's not forget that. And that name for, anticipatory breach is repudiation. So the repudiatory letter, came in May before the time for performance. So the question before the court was whether the plaintiff could sue for breach of a contract when it had not yet occurred, when the time for performance had not yet come, right? And the court held that the plaintiff did not have to wait until performance was due to be able to bring an action. That when a party has unequivocally renounced performance, when a party has unequivocally said that I am not going to perform this obligation when the time of performance comes, it is only logical that the plaintiff, would not just sit idle and incur expenses and prepare for performance that will not happen, that the plaintiff can sue before actual breach happens. And, the same thing also happened in Frost and Knight. Defendant promised to marry the plaintiff when his father dies. But while his father was still alive, he broke off his engagement to the plaintiff and announced that he was no longer going to fulfill his promise. The plaintiff, did not have to wait for the father to die for her to bring an action for breach of contract. She went ahead and brought an action for breach of contract, and the court held that she could do that. She did not have to wait for the time for actual breach to happen for her to bring an action for breach of contract. Then you see in the words of Caribbean White, in Commissioner of Works, Benue against DEFCON Limited, that among the several recognized forms of breach, repudiation by either party of his obligations under the contract is an accepted method of discharge of contract. Repudiation occurs when a party by words or conduct conveys to the other party that he no longer intends to honor his obligation in the agreement when they fall due. So repudiation, which may either be express or implicit, operates as an immediate breach and discharges the person repudiating of his obligations in the contract. So this explains, this is a very succinct explanation of what repudiation simply means. It entitles the party to bring the contract to an end, even though performance has not become due. So when a party, repudiates the contract, as I said earlier, it doesn't automatically bring that contract to an end, right? What happens is that party has some options. The aggrieved party, that's the innocent party, has some options, 2 options. The aggrieved party has the option to accept the repudiation and treat the contract as discharged, right? Just like in $2. Or the other party could, or the other party could decide to reject the repudiation and treat the contract as subsisting and wait for and treat the contract as subsisting and then go ahead and wait for performance, and then hold the other party responsible for breach of contract. Whichever one the party, chooses to do, that is his right to do it. So the party could either, discharge that contract and take legal action immediately, treat the contract as discharged, absolve himself of his performance of his own part of the contract, or he can go ahead and wait for actual breach to happen, for the time of performance to come, when the other party would now decide that he would not be performing his obligations. However, once the party chooses to terminate the contract and to keep, to terminate the contract, or to keep it subsisting, once he decides to either accept the repudiation, terminate the contract, or reject the repudiation and keep it subsisting, he's not allowed to change his mind. So you can't appropriate and reprobate. You need to choose one, right? He's not allowed to change his mind. But, that party has that option. But then once that option is made, you can now go back and say, no, I want to do the other one. I want to pick the other option. In Udom and Michelet Sons Limited, the Supreme Court adopted the following statement. The Supreme Court adopted the following statement. Once an innocent party is not, an innocent party is not ordinarily bound to treat the contract as discharged. He may, at his option, elect to treat the contract as continuing, or he might take, he might say that the breach by the other party has discharged his liability. If he chooses the former course, he can still sue for damages for any loss sustained as a result of the breach. But the contract, with all its terms and conditions, remain alive for the benefit of the wrongdoer, as well as himself. Each party is entitled to hold the other party on his bargain and to continue to tender due performance on his part. So this also explains what I've been saying about the options, available to the innocent party. Once, the innocent party, once the other party, the repudiating party repudiates the contract, communicates his intention not to go ahead with the contract, the innocent party has two options. He can accept the repudiation and discharge the contract, or he can reject the repudiation and keep the contract subsisting. But whichever one he chooses to do, they are both of his options, and he can't go back on his words. So that's what happened in Avery and Baldwin. In that case, a ship was required to be loaded, So Avery had a ship, right? And he entered into an agreement with Baldwin that Baldwin would load a cargo on his ship. And, that he would load the cargo on his ship called Odessa within 45 days. However, Avery, the ship owner was told before the 45 days expired, Baldwin told him that, he would not be loading the ship. The 45 days had not yet expired, but he told him he wouldn't be loading the ship, But then Avery decided, he chose not to terminate that contract, not to accept the repudiation by Baldwin, but to reject that repudiation and keep the contract subsisting. And so he just went on and, continued to perform his own obligation. He kept the ship, waiting to be loaded, ready to be loaded. And 45 days came and it wasn't loaded. However, before the expiry of 45 days, right, a war broke out, and both parties were now in enemy countries, in enemy territory. And so the contract automatically became illegal. And everyone went to court to seek damages, right? But the court held that you have already chosen what you wanted. You've chosen to reject the repudiation and to keep the contract subsisting. And, you can't seek damages now that the breach has occurred, because, the breach has been overtaken by frustration. And you know that when, when a contract becomes frustrated, the other party, the loss lies where it falls. The party, whoever it is that suffered the loss would suffer the loss. The other party, he can't move the liability to the other party, so he couldn't seek damages from Baldwin. So that is one of the disadvantages of, not accepting the repudiation. So once the person has intimated that he would be repudiating the contract, the other party who does not accept it also keeps himself, open to such an option, such a circumstance where the contract becomes frustrated and he can't recover damages anymore. So in contract law, a party could actually try to discharge a contract for a bad reason. And for a contract to really be considered discharged, it has to be a legally adequate reason, right? If it's not legally adequate, then that is not a proper discharge. The other party is not, discharged from the contract. But then there are instances where a party would have terminated the contract for reasons that are not adequate, that are not sufficient, right? On grounds that are not sufficient. But then eventually he finds, or he brings forward a justifiable reason. In such a case, the courts would not, on the basis of technicality, deny that party has, denied that contract has been adequately discharged. And there is also something referred to as waiver or delay, right? So even where there is valid grounds for discharging the contract, a party who fails to act promptly may lose his right, to rely on that discharge. For instance, if a party continues to treat that contract as valid, even though he or her, even though he or she has repudiated that contract, and, even though he has given the impression that the contract is repudiated, he might still be held liable. So there's something we refer to as waiver. When you have a right, and instead of enforcing your right, you don't do anything, you don't take any valid steps, right? You might be held to have waived your right to terminate that contract. And you would see that in the case of Bayo Kuku. You see that in the case of Bayo Kuku against Per Maruf Contractors Limited. So in that case, what happened was that Bayo Kuku engaged Per Maruf Contractors Limited to roof a building, right? So at the point, he issued a letter repudiating the contract because probably he wasn't satisfied with the performance or the progress of the work. So he tried repudiating, he attempted to repudiate the contract by issuing a letter of repudiation. However, even after the letter had been issued, he allowed the contractors to continue to complete the work. Of course, the letter was, issued, but the contractors obviously rejected the repudiation because they continued to work, right? They continued to hold the contract as subsisting and they went on to work. But what happened was that Bayo, did not take any step to actually enforce, to actually, show that he really meant to repudiate that contract. He allowed them to continue to work and to complete the work without any objection, without any further objection. He accepted the completed work, right? So instead of rejecting it, he accepted it. He didn't ask them to stop, right? So even after the termination letter had been sent, he permitted them to remain on site and to continue to work. Then he now took delivery, after they had completed the work. He accepted and he started using the completed roof work. It's like he moved into the house or he just started using it. So in that way, he was accepting. He was accepting, the work that they had done, the performance. And so he went to court, and in court, he was trying to argue that he repudiated the contract, but the court held that he had waived his right to terminate that contract when, he accepted the work, when he allowed them to continue the work and all that. So the court held that he had waived his right to terminate that contract And in fact, what he had done was to affirm the contract.